In commercial real estate loans, a borrower is protected from paying anything more to a lender after a foreclosure sale if the value of the property was not enough. But under California law, the third party that guaranteed that loan, they have to pay the rest, unless they can prove the loan was a sham. A new California Court of Appeals decision clarifies how the sham guarantee defense can be used in commercial loan guarantees.
Prior to this case, California law was very vague and ambiguous as to when a guarantee might be considered a sham. It blended concepts like alter ego and lender manipulation.
And they'll just mix them all up together, like they're throwing slices of apples and slices of oranges in a bowl. What our case law did is they sort of took those apples and oranges out of the bowl and they separated them. And they said, no, this is the apples and this is the oranges. And you may either prove this or you may prove that. And those are separate things.
In the Bradley case, Alan Matkin's attorneys Kenyon Harbison and Mike Farrell took apart a guarantor's claim that they and the borrower were one and the same, and that the lender structured the loan to make it look otherwise after a non-judicial foreclosure.
The court found that the guarantees were enforceable, that these individuals had taken advantage of using corporate entities for their own purposes. The lender here had not tried to manipulate the loan structure in order to shift these individuals from the role of borrower, who'd be protected after foreclosure, to guarantor, who'd be unprotected.
The court established a clear two-part test to determine if a guarantee is a sham.
Is the guarantor already liable for the debt?
It, I think, heightened the burden that the guarantors probably have to meet about proving that they were the alter ego of the borrower. Because prior cases had just sort of thrown that term alter ego around, but they hadn't really given any definition to it.
Next, even if the guarantor is not already liable for the debt, the guarantee may still be a sham if the court finds the lender manipulated the loan structure to get around anti-deficiency protections. So the court made that a very separate test and made it easier for lenders and borrowers and guarantors to analyze what they'll have to look at to see if guarantees will be enforceable in the future.
Clarity to the law also brings clarity to how borrowers and lenders can better protect themselves under it.
Make sure you are very carefully documenting the separateness of your corporate borrower from your individual guarantors.
People have relationships, and so it's easy to refer to an individual that you're dealing with as your borrower, even if that person is actually going to be the guarantor. Whether that borrower, that company that becomes the borrower, is actually just an alter ego of the guarantor.
Parties should be careful to ensure that the borrower entity is validly formed, all the right paperwork is filled out and submitted to the Secretary of State's office, that it has enough capital to operate, and that it maintains its own separate existence from its owners, which in most cases are the guarantors themselves.